Without objection, the chair is authorized to declare a recess of the subcommittee at any time. Welcome everyone to today's hearing. Field hearing on evidence, well, it's not a field hearing, on evidence of current and ongoing voting discrimination. Now I recognize myself for an opening statement. Today's hearing on evidence of current and ongoing voting discrimination is part of a series of hearings that the House Judiciary Subcommittee on Constitution, Civil Rights, and Civil Liberties will hold over the course of this year to assess the current need for a reinvigoration of the preclearance requirement of Section 5 of the Voting Rights Act, 65, to consider other ways to strengthen that landmark civil rights statute. I'm not sure why we say reinvigoration. That seems to be one of the words we toss around. It's not really a reinvigoration. It's a degradation. Section 4 was cut out, so we need to have a Section 4 to activate Section 5. Section 5 has been made dormant by the Supreme Court saying Section 4 wasn't adequate, so we need to find a new test to awaken the dormant power of Section 5. The Voting Rights Act of 65 is widely considered the most effective civil rights statute ever enacted by Congress. The act was enormously successful in expanding federal authority to protect the fundamental right to vote. And one of its central enforcement provisions was its Section 5 preclearance provision. The provision required certain jurisdictions with a history of voting discrimination against racial and language minority groups, predominantly those that tended to be in the Deep South, to obtain approval of any changes to their voting laws or procedures from the Department of Justice or the U.S. District Court for the District of Columbia before those changes could take effect. The purpose of the preclearance requirement was to ensure that jurisdictions that were most likely to discriminate against minority voters, as shown by a finding of Congress, would bear the burden of proving that any changes to their voting laws were not discriminatory before such changes could take effect, and therefore not discriminate, in fact, against people that they shouldn't be taking that action against. It provided a mechanism to assure that the new voting rules and practices of jurisdictions with a history of discrimination were fair to all voters. So we had this when we passed the Voting Rights Act in 65. There was a list of jurisdictions. It was renewed. There was a list of jurisdictions. And then in 2013, in Shelby v. Holder, our Supreme Court said, well, what we did in the past with Mr. Sensenbrenner, who was chairman of the committee, and what the House did by a vote of like 390-something to 33, and the Senate by 98 to nothing, was not adequate. That a finding by the Congress of legislative action was not sufficient, that the court, which is generally kind of says it's bears deference to Congress, was going to jump in and put its opinion above Congress. So what the preclearance requirements did is it prevented potentially discriminatory voting practice from taking forth before they harm minority voters, which was the purpose of these laws, so would have found the courts. And in this way, preclearance proved to be a significant means of protection of the rights of minority voters. This is why Congress had repeatedly reauthorized preclearance provision, overwhelmingly bipartisan, most recently in 2006, and Mr. Sensenbrenner was the chairman of this committee at the time and did a great job. It was 390 to 33 in the House, and the Senate was 98 to nothing. Unfortunately, the Supreme Court effectively gutted Section 5 in 2013, Shelby County versus Holder. It struck down the coverage formula, Section 4, that determined which jurisdictions would be subject to the preclearance requirement. As a result, the preclearance provision remains dormant unless and until Congress adopts this new coverage formula. So we have to have hearings to show the court that we've taken information and our findings are based on fact. We've heard in the 4 hearings we've held so far this year on voting rights, and most recently in Memphis, Tennessee, and we will further learn at today's hearings. Since the Selby decision, we've seen formally covered jurisdictions implement numerous discriminatory voting measures. North Carolina, for example, passed a sweeping voting suppression law that a federal appeals court ultimately held to be unconstitutional, finding that it intentionally targeted African Americans with almost surgical precision. But of course, by doing it after they put it into effect, they had their desired effect, which was to limit African American voting. If they were under the preclearance requirement, the courts could have stopped them from doing it before they did, as Mel Brooks would say, that voodoo that they do so well. We will also hear about recent measures to make it difficult or impossible for minority voters to exercise their right to vote. These measures include polling place closures and relocations, the purging of voter rolls that disproportionately target racial and ethnic minority voters, discriminatory photo ID laws, and the restrictions on ex-felon voting, all of which are designed to make it harder for African Americans and other racial and ethnic minorities to vote. Last week in Memphis, we learned about Tennessee's third-party registration law that would impose draconian penalties on groups like the League of Women Voters, who work to register new voters for minor errors and omissions in registration forms. It made it a criminal effort for people to do so, in essence. Back in May, we learned about a similar law in Texas and about many other examples of voting discrimination in that state. And we've seen states engage in racial gerrymandering designed to dilute the strength of minority voters. In the absence of an effective pre-clearance formula regime, there's almost a certainty that these discriminatory measures will undermine the voting rights of racial and language minority voters and erode our democracy. While Section 2 of the Voting Rights Act, which prohibits discrimination in voting, remains in effect, it is by itself less effective, significantly more cumbersome, and often prohibitively expensive to enforce the Voting Rights Act. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place. Requiring discrimination victims to rely solely on such a remedy effectively neuters the act. The onus, therefore, is on Congress to create a new coverage formula to reinvigorate the act's most important enforcement mechanism, its pre-clearance requirement. I thank our witnesses, our members, for being here today. I look forward to a fruitful discussion, and I'd now like to recognize the ranking member, Mr. Johnson, for his opening statement.